Number 5 is about the provision of an easement agreement for continued use of the private driveway through this quarter section for the larger operation off to the west. Number 6 deals with the relocation of that open discharge system and confirmation from a safety codes officer that it has been relocated to meet the setbacks as required. And then the ACO Electric has a tendency to have missed the right-of-ways in this particular part of the county. So they have facilities that across the parcel. And number 7 is them asking for a right-of-way agreement to take in their current facilities. With that, Mr. Chairman, I'm happy to answer any questions. And the applicant may also have some comments he wishes to make.
Okay, so I'm gonna change a little bit here from protocol. Could we get you to do, since these two are tied together, and I have some concerns with the private road situation, I would just like to understand better on how the second development permit is going to go. I just don't see us approving one and then not approving the other because of some issue or concern. Mr. Clark?
That was a question that I had directly, is how do we ensure that both have access by road into the properties?
So, Craig, are you okay giving us the Coles notes or doing a presentation on 7.2 since these two are so tied together?
I can, Mr. Chairman. You can just scroll down to the right page.
Page 53 in our package. I'm not sure where it is on yours. So.
It looks like the agenda numbers are a little off today. I think it's 42 is the map itself that I'm going to bring you guys to, but the bulk of...
Okay, it's 35 on mine.
Yeah, it's 35.
Transposed somebody's. Page 35, gentlemen.
Okay. So maybe on this one, I'm going to pick another sketch to show a little bit what's going on the site. So we'll start on page 42. Andrew, if you can bring that up. You already got it there. Great. Okay, so this is the northeast 4 quarter section. And largely you can see the pink outline is going around the existing hog operation. The large brownish pool to the north, there is a wastewater lagoon on site, but that's not it. That's the water reservoir. The wastewater facilities are the 2 smaller ones that are on the west side. And the setback from the wastewater lagoons on the west side is much smaller than open discharge. It's only 30 meters. There is an open discharge on this site, but it's within the cluster of buildings that you can see, and it already meets the requirements of the private sewage disposal requirement. So this large 61-acre parcel is basically the minimum amount to encompass those existing buildings and facilities and meet those setbacks, which is how the parcel ends up being as large as it is. The access to the remnant is off the Range Road, and it's at the very northeast corner that you can see on the drawing. So that is taken care of off Range Road 17-3, and 17-3 is developed to facilitate that access and continues on to the north. There is ACO Electric facilities coming down on the east side of Range Road 17-3, and that also requires an access. In this particular application, it's recommended that we do take road widening for 17-3 in the future using the road acquisition agreement. In terms of the very northeast part of the proposed parcel, where we're going past the berm for the water reservoir, that about 4.95 meters would take us just to the toe of the berm, which means the future roadway for the town's road allowance would not interfere with the actual physical facility of the berm holding back the water reservoir. The regional water line does serve this parcel and actually is located on the right-hand side or the east side of Range Road 17-3, and then it kind of juts in near the driveway that you can see. And the point that ties this with the previous application is the road that you can see going out in the lower right corner, first down 17-3, and then it sweeps to go into a private road across the other quarter section before it gets over to the southeast of 3, which is, across the southwest of 3. And then over to the southeast of 3, which is the panhandle for the previous application. And our location map, maybe we can go down to that. Andrew, if you can scroll down to 45. So we don't show the private driveway because we only show our own private roads, but you can see the large pink block is a proposed parcel for the hog farm operation. And running right through where you see the 3 in the middle of the screen. That's where, all the way over to 852, that's where the private driveway is.
Can you bring
So
up
the
another map?
recommendations in this case is to, it does include a requirement for an access easement for this property to cross the other land owned by the applicant using that private driveway, and then across the 1 mile distance to be able to get out to 852. Other conditions include sorry for the background noise, the standard conditions of subdivision, sketch, taxes, and rural addressing. I mentioned the rural acquisition agreement. We're recommending for 17-3, a new power right-of-way agreement for the power right-of-way agreement for ACCO Electric. And then the item number 6 shows the various titles that would be involved in creating that access easement to make sure that whoever owns and operates the larger hog operation has use of that private driveway that's historically been used to make it over to Highway 852.
Okay, thank you for that, Craig. Any questions, concerns from our board right now? Go ahead, Mr. Clark.
I do, it depends which one we're talking about or both.
We'll take both as we go. And
Okay, what still concerns me is with easements, are we ever going to have problems with roads, or should we be having that road to the north being built for future for this hog operation? Because if those two properties sell individually in the future, are we going to have the people in that housing where the house is and that security barn, are they going to be complaining in regards to cattle runners going past them all the time on the road that they own?
well, and I do have that concern as well as who maintains it.
Or hog trucks, but I mean.
So, Mr. Chairman, so the easement's properly written, and they do have to meet the county satisfaction for that point. Basically means that a party knowing it would see that on title as they buy, and it's kind of part of their due diligence to know that, yes, that's part of the arrangement, that they're going to be allowing someone else to have vehicle traffic coming past that yard, and they have to facilitate that. We tend not to get into maintenance issues on the private matter. And in terms of this driveway has been used for many, many years. When I've looked at it, the need to switch that over to public infrastructure and a public responsibility is why I'm recommending the easements as opposed so keeping it on the private side and private responsibility to maintain and fund, as opposed to making it a more of a public responsibility for us to facilitate and a new expanded road to get to this operation.
Okay, go ahead, Mr. Clark.
Just to further that back to Craig, like you said, the maintenance would become more of an issue between the two property owners, but the county of Stettler at that point would end up with calls in the middle of it. So how do you ensure, because you're going to have somebody that owns a section road that is driving in and out with possibly a pickup and a small SUV, and then you've got bigger units either bringing feed in or bringing animals in or out. That could be really giving the worst to that road. Good operator would maintain that section, I'm sure, but in the same sense, we can't look into the future on that either.
So can we just scan out a little bit on this map you have in front of us? So where's the next road going north and south that's actual usable roads? Like past the big barn, right there.
852 is a usable road. The other one is more, people drive on it, but it's not, I wouldn't call
So
it.
from the barn north, those two sections there, keep going. Is that a travelable road? Like, could you get a liner up and down there?
It's more of a weather road, I would call it, or?
Yeah. My fear is on a go forward basis that, and I'm kind of with you, Mr. Clark, in the fact that if we don't have this fairly solid in how this is going to be dealing, they sell the house and the shop to somebody else, and that individual gets, loses their mind. And then what do we do to get, are we going to be building 2 miles of road for one pig barn? So,
I do have another question.
okay, go ahead, Mr. Clark.
Second question I have is on manure storage on the application. I know we've got the proper setbacks, but what do you do with lagoons that are full if it ends up being that barn on the 61 acres is the only the only piece of that operation if the other properties are sold. Where does the manure go and how do we ensure that there is proper coverage? Because we will take the complaints from neighbors on that also.
Okay, so I would like the applicant to address that a little bit, Mr. Chairman, if he can. You guys hear me okay? A little bit of feedback there.
Well, hold on, Craig. I just want to know, you talked about a statutory plan. Does this affect their CFO permit at all? Can you answer that, or is that something?
No, Mr. Chairman, it does not. And their CFO permit would continue to be enforced. That includes all the requirements around manure management and both in terms of storage and ultimate disposal, either on land that the applicant owns or the land or that the applicant is able to access. So my understanding from the property owner is that they intend to still have the right to have the manure spread on the lands that they've historically been using. Under a use agreement to actually satisfy their CFO approval requirements.
Okay, fair enough. Mr. Gender, you had a question.
I'm just kind of wondering whether it'd be better off, say, like that first half mile, include that in, say, like with the main operation of the barn, and then have an easement that the acreage could possibly have on there. Because I wouldn't want to see like being confined, like it's been mentioned around here, that all of a sudden you don't have access to your main operation. So that I'm just kind of wondering whether that would be more applicable on this situation.
So, Craig, where do you think there's that? I think what he's
So,
talking is that whole
Mr. Chairman,
loan goes.
I think
Go ahead.
okay. I think I did get the general gist of the question. And in reviewing this with the applicant, when they were preparing the application, we did talk about the possibility of a panhandle all the way 1 mile from the barn over to 852. The issue is that we can't physically link that together because we have our own road allowance, 17-3, running north-south. And to facilitate that physical link, we'd have to actually go through a road closure process. So in lieu of that, we use legally binding access easement agreements that cross the land and can have drawings showing this is where the area where you agreed to allow us to continue having truck traffic.
Okay. All right. So, Mr. Perkins, we've talked lots about you. Now we'd like to hear from you. So you've heard the discussion, I hope, and kind of see where we're at. So can you give us your comments on this, please?
Certainly. Can you hear me all right?
Yes, we can.
Okay, thank you very much. And I'd like to talk about two things. One is the proposed subdivision where the barn or where the house is, and that other building there is an isolation barn. And so actually breeding stock are brought into that isolation barn, and they're held there for a number of weeks prior to moving into the main barn to assure that there would not be some kind of a break of disease that would get into the main barn. And so we've got that intermediate break there. So these two facilities are at this point in time are really tied because that small barn and the house are on the one piece of property, and so it's integral for the operations of the barn at this point in time. Could they be brought in from somewhere else? I guess that they could, but as long as that barn is operating, that is the easiest route for us to go. Regarding the roads, first of all, Red Willow Pork Farm is, just to give you a little bit more background, has a number of quarters of land there in the block, and we've already sold 8 quarters to our long-term renter, which is a neighboring family, and that have been farming it for a long time. They've been using the manure as well, and so we've sold 8 quarters. Tied to even that first sale is a manure use agreement that when it's several pages long in the sale agreement that provides for the application of manure to the land, and they have an option on the balance of the land that would be exercised in the future, and that same thing would apply to that. As well, our lawyer was doing an easement on that private road, so that if the land there was sold, that easement would remain in place, and there would even be an easement taken on the divided panhandle portion they were talking about on the southeast of 3 there. There would be an easement on that road as well. So it'd really be an easement on our own property, but that is to take into consideration anything that might happen in the future.
Okay, go ahead, Mr. Clark.
Just a couple questions back to Brian. If one is that manure use transferable if something was to happen to that land in the future? Is it written in that it has to be transferred, or would all of a sudden you lose the accessibility?
The manure use agreement is attached to the land.
And legal court law, whoever had it would be if somebody else bought that land, they would have that manure use agreement.
That's right. That's exactly right.
Just like an easement. Okay, the other question is the water line that follows that road in. Like typically, it's not, the county doesn't put water lines across privately owned land, but with that road being there, if this land, like, do we have that registered as an easement on that so that we have accessibility? I can't see there being any issues because it's servicing the two subdivisions we're talking about.
Yeah, they'd certainly be highly motivated to let us on the land, but regardless, we do have legal right of way across the various quarters because it kind of borders the land. So there's actually 4 different easements that play into that. So we do have access on both sides of the fence.
Regardless of ownership by any.
That's absolutely right. This instrument won't affect the instruments we have registered on the titles.
Thank you.
Okay, any questions and concerns now that we've done these? So what I'll do is we're going to go back to page 38 of our package, and we'll do subdivision 2023-5 southeast 034017 west of the 4th. So this is the first one we looked at, gentlemen. This is the house facility and the initial small barn that they house for quarantine. Is everybody clear of what we're looking at and what the recommendation is? We have no other questions. I see, Mr.
No questions, but I'll move that we accept it as presented with recommendations in place.
Awesome. Okay, so we have a motion to accept it with recommendations. Questions or concerns? Seeing none. All those in favor? Okay, that's carried. Okay, and then now we're on to 7.2, subdivision 202306, northwest 044017, west of the 4th, of course, page 35 of our package. This is the subdivision of the actual barn facility with lagoons and water holding ponds. Everybody's clear? I see nodding of heads. I will need a motion. Mr. McKay?
Yep, I voted so.
Okay.
With the recommendations.
With recommendations. Any questions, concerns? Seeing none, I'll ask the question. All those in favor? And that is carried. Okay, there we go. Thank you, Mr. Perkins. Thank you, Mr. Teal. We'll go back up to your report to Development Officers 5.1.
Thank you very much.
You betcha. Thank you.
Take this one, Mr. Chairman.
All right.
So the Development Officers Report just has a breakdown of the development applications that we've been working on. We're up to number 67. About this time last year, we were up to number 52. We're seeing, kind of the same thing. It's spread across the board as far as the types of development. We're still seeing a fair number of housing going up, additions to housing, that kind of stuff, and a little bit of everything mixed in there. So it's been pretty busy. You know, it's been great having Greg on board to help out with a lot of this, so.
Do we have a report of, like, we have a construction value, and I'm just gonna pick on the very first one there, 15,000. They may pull the permit, but do we know when they're actually finished and the completion of that?
So annually, planning development provides these reports to the assessors, who then do the follow-up.
Oh, okay. Is there a way that we could see that somehow? That we know?
That would be more of a report coming out of the assessor's office that we can show year-over-year changes in new improvements.
Okay.
And that would capture quite a bit. So yeah, we can do that pretty well anytime after the end of February is when that's finalized.
Would you gentlemen like to see that report year over year? So could I get a motion to ask administration? Mr. Clark, ask administration to bring back an assessor's report year over year for MPC going March kind of thing. Does that work?
Yeah. So it'll be, what it'll represent is the December 31st to December 31st changes, because that's when that's the snapshot in time we take for assessments annually. And that's, prepared at any time. Well, it's due to the province at the end of February. So by March or April each year, we can present that, and we can do one for the next meeting just to catch up.
Okay. Are you guys good with that? Mr. Clark? Okay. All those in favor? That's carried. Okay. Anything else from the development officer's report?
Well, that's it. Any questions or concerns other than the ones already discussed?
Okay. Thank you. We'll have Mr. Stevens receive for information on the development officer's report.
I'll give you that.
That's carried. Okay. Going to 6.1. Who's taking this?
Thank you, Mr. Chairman. The purpose of the application is to consider a permitted use development permit application for an ancillary building at garage standard size with a variance to allow it to be placed in the front yard and also a variance to reduce the front yard setback from 25 feet to 18 feet, which is a 28% reduction. Background on the property, subject property is located in the Rochelle Sands Heights subdivision. The applicant has a permit for and is currently in the final stages of constructing a dwelling on the subject property. The applicant has now submitted an application to construct a 660 square foot garage in the front yard. Due to the placement and the size of the dwelling, access to the rear of the property by vehicle is not possible without trespassing on neighbors' lands. There is a utility right-of-way along the front of the subject property. The proposed improvement does not extend into the right-of-way, and the applicant has provided a letter from the utility company indicating they have no issue with the development, provided that the development stays a minimum of 1 meter away from the utility. The applicant has made arrangements with the utility company to relocate the gas meter to accommodate this requirement. The application was referred out to administration. We did get one concern back from Environmental Services about the proximity of the garage to the shutoff valve for the water. After discussing this with the applicant has agreed that if the valve needs to be removed, it will be done so at his cost, and Environmental Services has asked that it be placed on the outside of the property line, so it will be on the county land. But again, that'll be done at no cost to the county.
So will we have an agreement in place somehow that we know that this is dealt with? Like, it's one thing for us to say it here today and have Environment Services and this guy, house sells 30 years from now, and then it goes, and then we end up having a kerfuffle.
Well, it's a condition of the development permit. So if it is too close, then it'll have to be removed prior to construction, and it will be moved on the county side of the property line. So there will be no access issues.
So would we have some sort of tag with this, with Environmental Services, so that they deal with it? Like, I mean, how will we know? Because this development permit will get put into the storage bin, and after 10 years, we won't know that this needs to be changed because nobody will be here.
Well, it would have to be changed before the building gets built.
Oh, I see. Okay. So we're going to actually do this physically now.
Right.
Yeah, fair enough.
Just to clarify, we're relocating the valve, not removing the valve, right?
Right. Okay.
Mr. Clerk?
The comment with regards to not being able to go past the garage, is there a house on the back of the lot?
It's a ways back on the lot, but you see how wide it is and where it's placed. It's fairly narrow on the side yards. So to get past there with a vehicle would be pretty difficult.
What happens when somebody moves or something? They're gonna back everything from there to the road, or? Sorry. What, if they were to move out of the house, or would the movers have to back everything from the house past the garage?
Yeah, there's still quite a, like if you look at what Andrew has on the screen there, there's still quite a bit of space between the garage and the side yard. So he's got room in the front, but like if you'd have put the garage in the back, it would have been pretty impossible to get.
Oh, okay. I see what you're saying, that at the back of it, okay. Yeah.
Right front.
Yeah.
Mr. Gender?
Is there, can you pinpoint where the approximate location of the shut-off valve is? On
You
the,
got a picture there.
See it right?
Right there,
from the aerial.
the map.
If you go back, I think they had the water utility, you can zoom in, or is it the gas line utility they have?
It's electrical and gas is all they show on this one.
So, in this
The
subdivision,
green printing is?
the shut-off valve will be just to the right-hand side of that blue line, which is the electrical line. The shut-off valve will be, and just inside of the property. So about where that green line starts on the right-hand side is about where the shut-off valve is.
Because generally when you're install, let's say like a shut-off valve, if it should always be on the outside of the property.
Right.
I'm just kind of wondering, why is it going to be that landowner's problem for relocating it
This,
to the municipality?
So this subdivision, for whatever reason, the shut-off valves are all on private property. So that's why if we're gonna move it, we want that problem fixed and it will be put on the outside in the county right of way. So that way, if ever we have to turn the water on or off, we don't need permission from the landowner to go in to do that. Whereas right now, the valve is on private land. So we have to get permission from them to go on to turn the water on and off.
Sounds like this was a developer's decision, not ours at the time, so.
Exactly. Okay.
But, yeah.
But that's why if we have to move it now, we want to fix it and get it where it should be.
Fair enough. Okay, any question and answer?
Thank you.
Okay, Mr. Stevens?
I'll make the motion that we approve this with staff recommendation.
Any questions, concerns? We went through this. Seeing none, I'll call the question. All those in favor? That's carried. So did we ever look at the whole ancillary building in front of these? Like,
That's gonna be part of the major land use bylaw review.
okay, because we have talked multiple times about this. Okay? I'm not sure why we went that. We always wanted to put it in the back, but I get when you have,
It's in a hamlet. Yeah, it makes sense in a hamlet, doesn't make sense at the lake, so.
the lake is always very special, right, Justin?
I get to ride on the short bus.
Yeah, that's why you ride the short bus, absolutely. Okay. Next one up, I take it you're taking. Okay.
Thank you, Mr. Chairman. The application is to consider a permitted use development permit application for a fence with a variance to the maximum height. So the subject property is located in the Anderson subdivision. The applicant recently was granted a permit to place a manufactured home on the property. The home has since been placed and has residents living in it. The applicant is proposing to construct an 8-foot-high privacy fence along the property lines. The adjacent property to the south currently has an 8-foot-high fence surrounding it. And this fence will be built to match that one. The property to the north has no fence around it. The application was referred out to administration with no comments or concerns received. So as the land use bylaw, the way it's written, if they were building a 6-foot-high fence, they wouldn't have even need to make an application to do so. But because they want the extra 2 feet of privacy added to the fence, it becomes a variance application. So that's what we're considering, whether or not to allow that extra 2 feet of fence. So in considering a variance, we have to make an argument whether it is going to affect the adjacent landowners' enjoyment or value of their property or interfere with any of the other amenities. So this fence doesn't promote, it doesn't make a a vision issue with any of the roads. It's not like it's on a corner lot that you're gonna be peeking around the corner, pulling out in the road and get hit kind of thing before you can see. It's basically just to add a little bit more privacy to their property, which in turn makes the neighbor that doesn't have a fence, gives them a little more privacy as well. So that was the reason that I felt this variance should be granted. So there's some pictures there that you can kind of see through, but the basic conditions that we always add. 1 year to begin construction, 2 years to finish. Location of the fence is to be completely within their property boundaries.
Sure, this fence will be done by the end of the month, being July.
Is the fence on the other side, does it have a permit? Did they get a permit? Okay. So we already have granted a variance to the one, so Mr. Gender.
Move it as recommendations, please.
All right. Any questions or concerns? All those in favor? That is carried. Thank you, gentlemen. Well done. I think we are down to 8.1, Mr. Gender. New business, permit fees and fines.
It was just brought to my attention that there's a young couple that bought a piece of property. They're going to get the permits. They had an opportunity to buy a home. They moved the home in, put it on blocks. And then I guess we had sent them a bill stating, okay, they had progressed on with no permit. I'm just kind of wondering if we can have leniency on this young man.
Well, I guess if you brought the whole issue to us, we might know a little bit more, but what you've told me so far is all I have is the development has gone ahead further than faster than Mr.
I can give just a reminder, make sure we leave the names of it.
Yeah. Like it's the property southeast of town here, like I have not seen it. It was just brought to my attention along that line. And they said if we can do something for this young family, by all means.
Your area? Your Dave's area? Huh? Yours?
Yes.
Okay.
Just to add a little more background information on that. It was, an application came in and it was a permitted use, so it's $100 application fee. When we went out to do the site inspection, it was noted that the home was already on the property, on a trailer, it wasn't on a basement or anything. But during our weekly discussions, it was pointed out that zero tolerance. And so the fee that they had to pay was an extra $100. So instead of a $200 application fee, it was instead of a $100 application fee, it was $200. But that was when that issue was brought forward about the development without benefit of a permit, that was the direction that we were given, was the zero tolerance. And on top of the no permit, there were also no road use agreements or overweight permits taken out on that, which we didn't pursue that one. It was just the beginning of development without a permit.
So the mover of the house maybe should have been a little bit the rules.
Yeah, so
I'm not, yeah.
I was just going to remind MPC that council recently changed this, so there used to be a flat fee. This fraction would have been $1,000 previously, but as council hadn't levied that in the past because of the steepness of it, council directed that the fee guideline be changed so that we simply doubled the application fee as Rich described happened in this case.
Go ahead, Justin.
So if I understand correctly, they weren't living in it, using it, it was still sitting on a trailer. Did they have utilities or anything along those lines?
no, it's just sitting on that trailer that was folded on.
So maybe what we should have done is charge them a $25 trailer registration fee. Is that where you're going, Mr.?
I'm not suggesting anything. I just wanted to make sure I understood the situation.
Mr. Clark?
Or possibly the overweight fine. Like it's awareness. It's definitely is awareness, but you know, if it was it's $100.
I'm thinking this is kind of a gentle reminder to these people that, I'll be honest, if this $100 is going to make or break them, they probably should not be doing that. Many of our surrounding neighbors, it's a $300 development permit fee. So I'm thinking we've made some adjustments already in that sense. So
They were not the ones that brought it forward. It was someone else that did.
yeah, no, I get it. But I mean, I mean, we're in a tough position. I mean, the young couple that came in and we were going to ding them $1,000 for starting their permit early. Yeah, I think this is a kind of a compromise, and I think we went the right direction. Go ahead, Mr. Clark.
Yep, there's other ones that have did the same thing, and we dropped it in the past, and we probably should have charged it. So
Start somewhere, right?
somewhere, yeah.
To my knowledge, since this new rule was adopted of the double the application fee, we haven't given anyone any leniency whatsoever. It's kind of dry.
And we've applied it consistently, which was the problem with the old fee, was not applied consistently.
Okay, fair enough.
Whereas being, say, like if they would have had to apply for a permit in order to bring it in, there would have been a fee for that, would there not?
They did apply for a permit, but they'd already done it before.
Yeah, they didn't apply for the overweight
Road inspection.
all permit. Yeah, they got away for a steal of a deal, honestly, actually, so.
So they did not have to have an inspection done.
Had they done it properly,
It would have cost them more.
way more, right? They would have had to have the inspection fee done and everything, and then that would have been considerably more expensive to them. So really, we're not, I don't think, being overburdened on it. Go ahead.
Just a question on that though, if I know when these properties become available, if it was a house to be moved, it happens very quickly. What would happen if, say, they were moving it into parents' land or something like that? Could they park it even where it wasn't going to end up at the end? Like what would we have? Just because in a lot of cases, movers will leave them on the trailer till the basements and everything else is done.
Even if they were moving it though, would they not need to have a?
Well, you should have a heavy, you should have a heavy permit. But really the whole piece, as far as an application permit, where you're going to put it.
Yeah, so I'll just quickly speak to, no matter how quick it is, we expect that you'll do the road use agreement, heavy haul permit, overweight, oversized, overdimension. And we have those all the time, whether it's an oil field request, construction request, we get last minute requests all the time. And we accommodate those, but I'll let Rich speak to the planning development side.
Yeah, if the road use agreements had been pulled out on this, I think we probably could have made the argument that they attempted to do the right thing. Or if we happen to see a house parked on somebody's land and come, through investigation, find out that it's just there temporarily, I don't think we would pursue, enforcement on that. But, like I say, the big thing for me was the no road use. Thankfully it was done at the time of year, it didn't damage the road, but pulling a house down the road on a trailer, it can definitely cause some issues, so.
Go ahead, Mr. Jenner.
PC for information.
Okay. All those in favor? Good discussion, gentlemen. I thank you for bringing that forward, Mr. Gender. That's good discussion.
Just once more, I think, communication. It's just one more thing that we need to get kind of rules out in front of.
And I'm not saying anything about this particular development, but I think for the majority, people already know the rules and they might just be, well, let's take a chance and see where we're at.
Young person, they may not know.
Yeah. I mean, no, you're right. But I mean, I know lots of young guys that would say, oh yeah, let's get it over there, take care of it. Right. And I would not be one of those that would not be in that.
And it's not just the young ones.
No, that's what I'm saying. I mean, right. There
Risk tolerance.
yeah, that's exactly it, right?
It's just overall clarity.
Yeah, absolutely. And we can never stop trying to educate, right? And I'll tell you what, the nice thing about having this discussion today, Mr. Gender, is the fact that if anybody watches this going forward now, we'll get a better understanding of why we do what we do when we do it, right? And then it's really, this young couple it was a good outcome for them, because if the county would have applied the road use and everything to them, they would have been considerably more expensive. I think they showed some tolerance and said, okay, you didn't hurt anything, but there's still this in place. So it's a pretty nice compromise. So, and I think you can bring that back to the person that, and then a lot of times I find it is that situation where you don't know the entire story till we start talking about it. Now, once you find out the entire story, all of a sudden it's a pretty good deal for this young couple.
If I bring it back to the person that made the
Request.
they will talk to the others.
Yeah. You betcha. Now it's just all around better. Okay. I don't think we have anything else to discuss. We got 15 minutes. We can sit here and do that or refresh your coffees. What do you want to do, Mr.
Quentin's outside.
Okay. All those in favor of adjournment. Next meeting, July 26th. Craig, will you actually be back here?
I will, Mr. Chairman, just in case you're wondering what it's looking like in Halifax.
Is that rain?
Yeah, 93% humidity.
Well, I'll tell you what, wrap a lasso around and bring it home.
Yeah, thanks.
Put it in your suitcase. Okay, all those in favor of Mr. Dave's motion, adjourned?